Good morning. This is your Kelso Report for Friday, March 30th. I'm your host, Clark Kelso. Today we have cases involving limitations of actions in torts and criminal law, juvenile law, an employment law case, and a habeas corpus. We begin with the Supreme Court of California and an interesting limitation of action involving a tort. In Quarry v. Doe 1, the plaintiffs brought an action against the Roman Catholic Bishop of Oakland, alleging that the defendant bore responsibility for sexual abuse committed during the 1970s by a priest then assigned to the Oakland diocese. Plaintiffs allege that in 2006 they discovered for the first time that the cause of their adult psychological injuries was the sexual abuse inflicted by priests when they were children. The issue facing the Supreme Court of California was whether their claims were timely, given the history of amendments to the limitation statute, CCP Section 340.1, over a 15-year period, where each amendment by the legislature gradually lengthened the limitations period, but for only certain types of claims, subject to a variety of different restrictions. The problem for the plaintiffs was that as of 1998, when there was one amendment, their claims had lapsed under the applicable law at that time. And although a subsequent amendment in 2002 revived their claims, the revival was expressly limited to suits filed within a one-year period of the revival. Given that express one-year language, which did not distinguish between discovered and undiscovered claims, the majority held the plaintiffs' claims were time-barred when the one-year period passed, even though the plaintiffs had not yet discovered their claims and would not discover them for several years until 2006. Justices Corrigan and Liu wrote separate dissents, both complaining that the majority had interpreted the amendments so that the plaintiffs lost their claims even before they knew they had them. While this criticism is, I think, accurate, the majority really cannot be blamed. The legislature, essentially, was trying to micromanage the applicable limitations period on a rolling basis, depending upon, frankly, the most recent news story. And in the process of trying to make all of those technical modifications, the legislature left a clear gap where certain plaintiffs' claims would be time-barred. Instead of micromanaging it, the legislature might have done better simply to embrace the common law discovery rule in general terms and let the courts apply that exception in each case to reach the most equitable result. The result in this case probably will result in some additional modification of the limitations law in order to see if they can't revive some of these claims. Obviously not for the particular plaintiffs in this case. Their case is over. Next we have a case involving limitation of actions, this time in a criminal law context. This one out of the Court of Appeal. The defendant in this case, People v. Hale, was convicted of over 50 counts of sexual misconduct with minors and was sentenced to 325 years to life. A number of the charges involved aggravated sexual assault of a child under 14 in violation of Section 269 of the Penal Code. Many of those occurred more than 10 years ago. The defendant argued that a 10-year statute of limitation was applicable because the statute provided that crimes requiring registration as a sex offender were subject to a 10-year limitation statute. Well, in this case, the district rejected this argument. The applicable statutes also provide that there is no statute of limitation for crimes that are punishable by death or by imprisonment in the state prison for life, or for life without the possibility of parole, or for the embezzlement of public money. A violation of 269 is punishable by a prison term of 15 years to life. In addition, for purposes of determining the applicable limitations period for a particular crime, the statutes provide that, quote, an offense is deemed punishable by the maximum punishment prescribed by statute for the offense, regardless of the punishment actually sought or imposed. Now, when you put all of these statutes together, it becomes clear that there is no limitations period for a violation of Section 269 that's punishable by a life term. The defendant also claimed there was insufficient evidence in the case that he committed forcible sodomy, but the evidence was rather overwhelming. In the particular charge challenged by the defendant, the evidence was that he put the girl on her stomach, got on top of her, sodomized her, and continued the act even though she complained that it hurt. And that was plainly enough for the court to affirm the conviction and the sentence. Next, we turn to a juvenile law case arising out of Los Angeles in the 2nd District. In Los Angeles County Department of Children and Family Services versus MC, the 2nd District had to deal with the conflict between two men, both of whom were having sexual relations with the mother when she became pregnant, and either of whom could have been the father. In the Superior Court, the 6-month-old minor was detained from his mother and placed with one of the men, EA, whom the trial court ruled was the baby's presumed father. Although EA and the mother had never married or attempted to marry, EA had lived with the mother for just 2 weeks before and 2 weeks after the baby was born, and the mother suspected that EA was not the biological father. Well, subsequent genetic testing revealed that another man, CR, is actually the biological father, and CR and the mother are now engaged to be married. The record also established that during the mother's pregnancy, CR had expressed his desire for a genetic test to determine whether he was the baby's father. He took the mother to prenatal medical appointments. He offered to help with associated expenses. His further involvement at that time was ended only because the mother cut off contact with him for a brief period of time. Nevertheless, the Superior Court denied the motion for CR to be named the presumed father. On these rather extreme facts, the 2nd District reversed the Superior Court, concluding there was no substantial evidence to support the conclusion that EA was the presumed father, and more than enough evidence to support the conclusion that CR was the presumed father. Frankly, a little common sense would have helped the Superior Court get to the right answer in this case. Next, we have an employment law decision. The plaintiff in Baker versus Mulholland Security and Patrol was terminated after just 13 days of employment. He sued, claiming a retaliatory and discriminatory termination in violation of the Fair Employment and Housing Act. The defendant asserted that the employee was terminated for performance reasons. Well, ultimately, the court ruled in favor of the defendant by summary adjudication, and it then awarded the defendant expert witness fees, even though there was no finding the plaintiff's action was frivolous. It's well settled that a prevailing defendant in an action under FIA may recover attorney fees only when the plaintiff's action was frivolous, unreasonable, without foundation, or brought in bad faith. Now, the courts of appeal are split about whether this same standard applies to an award of ordinary litigation costs to a prevailing FIA defendant. And no California case has specifically addressed the applicability of that standard to the recovery of expert witness fees as opposed to ordinary litigation costs. Well, the 2nd District concluded in yesterday's case that recovery of expert fees should be governed by the same high standard applied to attorney fees, since expert fees, just like attorney's fees, are not ordinary litigation costs, which are routinely shifted under the Code of Civil Procedure. They can be expensive and unpredictable, and because they can be unpredictable and substantial, could chill plaintiffs from bringing meritorious actions. Since the plaintiff's action was not frivolous, the 2nd District reversed the award of expert witness fees. Finally, we have a habeas corpus case with defendant in re Morganti had been convicted of murder in 1991, and that was related to heavy drug use at the time. In prison, the defendant joined Alcoholics Anonymous and Narcotics Anonymous and stopped abusing drugs and alcohol, and he was otherwise a model prisoner. Nevertheless, the Board of Parole Hearings denied an application for parole, ostensibly because he lacked sufficient insight into the causative factors of his crime, and was therefore a risk to the public. As I have reported in other cases over the last year, the lack of insight factor has really become a crutch for the Board of Parole Hearings to deny parole when nothing else in the record suggests a reason for denying parole. In re Morganti, the First District blasted the board for this practice and for denying the petitioner's application for parole. In addition to finding no evidence to support the board's conclusion, the First District held as a matter of law that even if the board makes a finding of insufficient insight, if there is not a demonstrable nexus between that lack of insight and present-day dangerousness to the public, it is erroneous to deny parole. That rule is going to give the courts of appeal greater ability to monitor the Board of Parole Hearings. Now, in this case, there was strong evidence that the petitioner was not a danger to the public, including the fact that he had been drug-free throughout his almost 20 years in prison. He participated in vocational and other programs, and he was now 59 years old and in declining health. The Second District ordered that the petitioner's writ of habeas corpus be granted. Now, because this case does involve the applicable legal standard for review, and this question of whether, even if there is a lack of insight finding, there still has to be a nexus to a finding of dangerousness, this is a case that could interest the California Supreme Court for further review. That's it for today's Kelso Report. Have a great weekend and a great day in the law.